Get ready for the dictation in 3, 2, 1, start. We may, in this connection, refer to a decision of this court in Meghraj Kothari versus Delimitation Commission and others 1967 1 SCR 400 stop. In that case, a notification of the Delimitation Commission whereby a city which had been a general constituency was notified as reserved for the scheduled castes stop. This was challenged on the ground that the petitioner had a right to be a candidate for parliament from the said constituency which had been taken away stop. This court held that the impugned notification was a law relating to the delimitation of the constituencies or the allotment of seats to such constituencies made under Article 327 of the Constitution, and that an examination of Section 8 and 9 of the Delimitation Commission Act showed that the matters therein dealt with were not subject to the scrutiny of any court of law. Stop. There was a very good reason for such a provision because if the orders made under section 8 and 9 were not to be treated as final, the result would be that any voter, if he so wished, could hold up an election indefinitely by questioning the delimitation of the constituencies from court to court stop. Although an order under section 8 or 9 of the Delimitation Commission Act and published under section 10(1) of that act is not part of an act of parliament, its effect is the same stop. Section 10(4) of that act puts such an order in the same position as a law made by the parliament itself, which could only be made by it under Article 327 stop. If we read Article 243C, 243K and 243 in place of Article 327 and Section 2KK, 11F and 12BB of the Act in place of Section 8 and 9 of the Delimitation Act 1950, it will be obvious that neither the delimitation of the panchayat area nor the constituencies in the said areas and the allotments of seats to the constituencies could have been challenged, or the court could have entertained such challenge except on the ground that before the delimitation no objections were invited and no hearing was given stop. Even this challenge could not have been entertained after the notification for holding the elections was issued stop. The High Court not only entertained the challenge but has also gone into the merits of the alleged grievances, although the challenge was made after the notification for the election was issued on 31st August 1994 stop para. This court, in its all humility, finds that the judgment which was passed by the apex court in the case of State of UP and others versus Pradhan Sangh Kshetra Samiti and others under bracket Supra was referred in a subsequent judgment of the apex court in the case of Bodulla Krishnaiah and another versus State Election Commissioner reported in AIR 1996 SC 1595 bracket 3 judge bench bracket close stop. The apex court, after quoting the judgment passed in the case of State of UP and others versus Pradhan Sangh Kshetra Samiti and others under bracket supra, in para 10 of the judgment held that if election process is set in motion, though the High Court may entertain or may have already entertained a writ petition, it would not be justified in interfering with the election process, giving direction to the election officer to stall the proceedings or to conduct the election process afresh, in particular when election has already been held in which the voters were allegedly prevented to exercise their franchise, in as much as such dispute is covered by an election dispute and remedy is thus available at law for redressal. Stop. The apex court also held that direction in that case of not declaring the result of election or to conduct fresh poll was not correct, but the writ petition was maintainable before the High Court under Article 226 of the Constitution of India. Stop. The relevant paragraphs 11 and 12 of the judgment are quoted. Stop. Thank you.